Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the case of SushilaAggarwal and others versus State of NCT of Delhi and another. It is a 2020 Supreme Court judgment being decided by a five-judge constitutional bench comprising of Justice Arun Mishra, Justice Indra Banerjee, Justice Saran, Justice M.R. Shah, and Justice Ravindra Bhatt. It is numbered at 60 in the list of AOR leading cases. And here a reference has been made with respect to Section 438 of the Criminal Procedure Code that provides the grant of anticipatory bail. Now, basically, this case is clarifying the scope and nature of anticipatory bail under Section 438 of the Criminal Procedure Code, and it is also aligning the objective of Section 21 of Section 438 of the Criminal Procedure Code with Article 21 of the Indian Constitution. Right now, first, before we go into the case, the court in this case is expounding on the meaning of anticipatory bail, and it is saying that expression anticipatory bail has nowhere been defined in the code. But if you look at the case of Balchan Jain, which has earlier been decided by the Supreme Court, anticipatory bail means bail in anticipation of arrest. Therefore, the expression anticipatory bail is a misnomer in as much as it is not as if bail is presently granted by the court in anticipation of arrest. Okay. And an application for anticipatory bail in anticipation of arrest could be moved by the accused at a stage before an FIR is filed, or even at the stage when FIR is registered but charge sheet has not been filed and investigation is in process, or at a stage after the investigation is concluded as well. And this power is vesting with the Sessions Court or High Courts. Right now, basically, what the issue arises in this case. Okay, so now the issue that arises in this case is that whether the anticipatory bail should be time bound, or whether the accused must surrender and whether the accused must surrender and apply for regular bail once he appears before the trial court. Okay, now it is a constitutional bench reference that is coming before the court in the case of SushilaAggarwal, and this case involves various other cases in which many high courts or many times the court has granted anticipatory bail but has imposed the time-based restriction. The petitioner in this case challenged these limitations, arguing that the plain reading of Section 438 does not allow such conditions to be imposed by default. The Supreme Court is basically looking at the conflict, and it is about to settle the interpretational confusion in this particular case. Okay, now the petitioners are claiming that anticipatory bail is rooted in Article 21, which protects the right to life and personal liberty of the person, and it cannot be artificially limited just by interpreting it narrowly unless it is justified by the facts. They are relying on the landmark judgment given in the case of Gurbaksh Singh Sibia versus State of Punjab, which held that anticipatory bail must be guided by judicial discretion and not by the rigid rules. And on the other hand, the respondents, they are contending that anticipatory bail it is of temporary nature, and especially in serious crimes they should come with the restriction. They are relying on rulings like Salahuddin. They are relying on the rulings like Salahuddin's case, like KL Verma's case, where court has imposed time-based restriction and required the accused to apply for a regular bail later on. Okay, now the constitutional bench in this case is delivering a landmark ruling, and the court is saying that the court is relying majorly and heavily on Gurbaksh Singh Sibia's case, which is a most celebrated case in the anticipatory bail jurisprudence. Court herein is saying that there you cannot assert any inflexible or mechanical restriction into Article 438, into Section 438 of the CRPC. In Sibia also, in Gurbaksh Singh Sibia also, the court has emphasized that discretion must be exercised judiciously and not based on arbitrary categories or assumptions. The SushilaAggarwal court in SushilaAggarwal reaffirms what has been held in Gurbaksh Singh Sibia and are saying that we are in agreement with the views that have been taken by the court in Sibia judgment, and the court should have complete discretion to impose conditions, but no hard and fast rule should be laid down limiting the discretion of the court. Okay, Now, Sibia has not supported any fixed durations, but it was later on misinterpreted by rulings like Salahuddin's case, like KL Verma's case, and therefore Sibia, the scope of Sibia was comparatively diluted or comparatively narrowed down by reading it into a requirement of time-bound protection. So Sushila Agarwal is also restoring the correct reading of Sibia and holding that Sibia also, the judgment in Gurbakh Singh Sibia also did not hold that anticipatory bail must necessarily be limited in duration, and that interpretation, if taken, is incorrect, however. Okay, now the court rules out that anticipatory bail should not normally be time bound. It can continue till the end of trial unless the court deems it is necessary to limit its duration based on the specific facts. Okay, now the court herein is saying that once the anticipatory bail, okay, the court is also narrowing down the view that has been taken in Siddhiram Satlingappa Mehtre, and also to the extent that 438 cannot be curtailed. 438 cannot be curtailed, and also criticizing the Salahuddin Sheikh judgment, which is taking an extreme view that anticipatory bail has to be necessarily limited in the time frame. Now, moving on, the court here in this case is saying that there is no statutory requirement under section 438 for surrendering. Okay, the accused does not need to seek a regular bail once anticipatory bail is granted, and court may impose reasonable conditions to ensure cooperation with the investigation, prevent so that it can also prevent witness tampering or protect the integrity of trial if it is required. In other words, if we say that, and what is anticipatory bail exactly? It is a safeguard and not a privilege, and it is a safeguard in line with Article 21 of the Constitution of India. It aligns with the constitutional values of dignity and personal liberty. Now, the most crucial element of this judgment is reaffirmation of Gurbakh Singh Sibia's judgment, and the court is reholding that the views in Salahuddin Sheikh and KL Verma are not accurately decided. There should be no fixed time limits on anticipatory bail. The discretion of the courts must not be restricted by arbitrary conditions, and personal liberty should always be the guiding principle. Okay, the decision in Sibia accords with the legislative intent behind 438, and therefore Sushila Agarwal's case upholds the reaffirms such decision, and it reaffirms the status of Sibia being the most authoritative precedent in the light of anticipatory bail jurisprudence. Now, this judgment is not merely about bail, but rather it connects procedural law directly with Article 21 of the Indian Constitution, ensuring that fear of arrest does not become a tool of oppression. The court is striking here in a careful balance, preserving the right of individuals to be protected from arbitrary arrests, and also leaving room for courts to impose specific conditions where necessary, because the cases, okay, the Mehtre case and the Salahuddin case were taking a very different approach. Whereas Maitre case was saying that no condition should be imposed, Salahuddin case was saying that there should be time limit on anticipatory bail. So court is criticizing and partially overruling both the judgments, overruling Maitre's judgment to the extent that court can impose restrictions, and overruling Salahuddin Sheikh judgment to the extent that there cannot be time limit imposed because there might occur various instances, and mechanically anticipatory bail therefore cannot be denied herein, right? So these Gurbakh Singh CBI is upheld. Siddharam Mehtre liberty-centric approach taken in Siddharam Mehtre case is appreciated, but however, when Siddharam Mehtre said that no conditions can be imposed, that view is criticized in this judgment. And it was held that liberty-oriented interpretation of Section 438 shall be taken in the light of Sibia and the present Sushila Agarwal's case. So this is it, which was held in the judgment of Sushila Agarwal versus NCT of Delhi. I hope the discussion is useful. For more such videos, please stay tuned with Legal Darshan. Have a great day.